हेलो अमित मोहब्बी मैं दोनों कॉलेज से बोल रहा हूँ आपके
Now we are online.
Suswagatam, Suswagatam, Suswagatam. Hearty welcome to honorable dignitaries, learning delegates, respected teachers and students. Here we are, the organizers at Kesimal Purval College of Arts, Science and Commerce College, Kamki. Some of the glimpses of our college. Honorable dignitaries, learning delegates, respected teachers and students, a very warm good morning to one and all. I, Dr. Shalini Sahande, feel privileged to welcome you all on behalf of Organizing Committee of one-day live webinar on Intellectual Property Rights, IPR, Patent and Design Filing. Rajiv Gandhi National Institute of Intellectual Property Management, Government of India, Nagpur. Well, Albert Einstein said, if we knew what it was we were doing, it would not be called research, would it? It is on occasion like this we get opportunities to test our knowledge and understanding. We look forward to get an exposure about what the best of the brains think about this very important issue of intellectual property rights, patent and design filing. I would now start with the introductory remarks by the convener of the webinar, Dr. Ratiram Chaudhary, sir, Head Department of Chemistry, SKPC, Nagpur. Over to you, sir.
Thank you, ma'am. Good morning to one and all. Okay, good morning to one and all. Respected dignitary present in the virtual webinar. The guest of today's webinar, Honorable Pro Vice Chancellor Dr. Satish Dude sir, RTM Nagpur City, Nagpur, and guest of honor and keynote speaker of today's event, Honorable Dean Science and Technology Dr. Prashant Maheshwari sir, RTM Nagpur City, Nagpur, and the president of today's webinar, respected Dr. M.B. Wagre sir, the principal of SK Power College, Kamki, and energetic and dynamic personality for as a resource person for this webinar, Dr. Bharat Suryavanshi sir from Rajiv Gandhi National Institute of Intellectual Property Management and Vice Principal of the SK Power College, Kamki, dear teachers and dear participants and ladies and gentlemen, on the eve of Azadi Ka Amrut Mahotsav, all the Indians are celebrating. So on the eve of this, Research and Promotion and IPC of SK Power College, Kamki, jointly organizing intellectual property rights for the patents and filing in association with Rajiv Gandhi National Institute of Intellectual Property Management. So well, and what is the main aim of this webinar? We know that today we are in the 21st century, and nowadays all the globe are forwarding in innovation and the patents and publications. Most of the people are publishing the data in the various ACI and Scopus Index journal, as well in the reputed journals like Scientific Nature and Nature Springer, SES and RSC, like that. But apart from that, we must try to forget patents, because if you see the data of the Indians, the Indian data, their patents are so less. So we mull over it, and we are going to be conducting the seminar on this IPR. because everybody know that if your data is reputed and your idea is new idea, innovative idea, so it should patent it to get the credit, because because the publishing, instead of publishing, that is patenting is more powerful, more you will get the credits. So for this, we have Dr. Bharat Suryavanshi as a resource person, and as well Dr. Prashant Maheshwari sir, Dean of Science and Technology, as the speaker for the today's webinar. And second most important thing is like to tell you that, ladies and gentlemen, for this webinar, we receive the overwhelming response from different part of the country as well abroad. We receive 1,170 registration from the different part of the country, and as well 15 to 18 registration from the abroad. So I must thankful my principal, Dr. M. B. Wagre sir, and management, Shikshan Prasarak Mandal, Kamchi, as well core committee member of IPR, as well the Rajiv Gandhi National Institute for Intellectual Property Management for giving me chance to organize such type of webinar to betterment of the young budding researcher as well the teachers and the innovative teachers. So thank you once again. Thank you once again. Thank you. Jai Hind.
Thank you, sir. Today we have with us Dr. Sanjay Dudhe sir, Honorable Pro Vice Chancellor, RTM Nagpur University, Nagpur, as our chief guest. Formerly, sir was serving as professor and head Department of Sociology, Taiwade College, Kuradi, District, Nagpur, Maharashtra. He is Academic Council member, Rashtrasantat Tukaroji Maharaj, Nagpur University, Nagpur. Sir has 24 years of UG teaching experience and 11 years of PG teaching with 10 years of administrative experience. He has chaired 40 sessions. He has written 7 books and published 3 articles. Sir has guided 5 MSW students and 10 students have been awarded with PhD under his able guidance. He has one minor research project to his credit and has published 35 papers. He has successfully organized 3 conferences and attended 55 conferences and workshops. He is chairman of various committees such as Board of Studies in Sociology, RTM Nagpur University, Nagpur 2017 to till date, Moderation and Revaluation Committee of RTMNU Nagpur University, Nagpur, Syllabus Upgradation Committee, UG and PG. He is Secretary, Alumni, Department of Sociology, RTM Nagpur University, Nagpur, 2010. He is member of various bodies such as Senate, RTMNU Nagpur University, 2005, Board of Examination, RTMNU Nagpur, Faculty of Social Science, RTMNU Nagpur, Academic Council, RTMNU Nagpur, Board of Studies of Sociology, Gondwana University, Gadchiroli, Scrutiny Committee of Social Science, RTMNU Nagpur from 2010 and 2017 till date. Sir is member of Teacher Welfare Committee and member of Research Recognition Committee. Sir has got wide professional distinctions along with the membership of various professional societies. So I now invite Sir to inaugurate the webinar and address the gathering on this occasion. Over to Sanjay Dudhe, sir. Sir, please.
Chaudhary, I am audible. Chaudhary.
Yes, sir.
Madam, I am audible.
Yes, sir. Yes, sir. You are audible.
Sir.
Yes, sir. You are audible.
Sir, audible.
Sir, but you are not visible, sir.
Okay. First, I congratulate our college committee and Rajiv Gandhi National Institute of Intellectual Property Management, Government of India, Nagpur, has organized a good seminar to benefit all of the faculties. And I also congratulate Principal of the College and Chaudhary sir,
Intellectual property rights are legal rights that protect creation and invention resulting from intellectual activity in the industrial, scientific, literary, or artistic field. The most common IPRs include patent, copyright, marks, and trade secrets. Many issues arise when a study group decides that it is technically prudent to incorporate an entity's intellectual property in the text of an ITUT recommendations. The issue vary according to nature of the intellectual property. When the intellectual property that is included is protected by an approved or pending patent, the study group must comply with the common patent policy for ITU, ITUR, ISO, IC, and the related guideline for implementation of the common patent policy for UTI, ITU, and ISO. Alternatively, this IPR policy beneficial of the research scholars, and this is very important and objectable to the all over the faculties. सर रतिराम चौधरी सर है, मुझे उतना इंटेलेक्चुअल प्रॉपर्टी राइट के बारे में पता नहीं है, क्योंकि जो लोग इस रिसर्च के क्षेत्र में काम करते हैं, उस रिसर्च के क्षेत्र में इंटेलेक्चुअल प्रॉपर्टी राइट का बहुत इम्पोर्टेंस है। और हमको पता है कि हम लोग काम करते हैं, हमारे पास पेटेंट रहते हैं, हम पेटेंट के लिए तो पैसे लगाते हैं या कुछ उसकी फीस है वो भी पेड करते हैं, हमारे पास बहुत सारे पेटेंट भी आ जाते हैं। लेकिन उस पेटेंट का हम जब काम करते हैं उसमें जब हम बोलते हैं कि एक्चुअली उस पेटेंट के ऊपर हमने वर्क करना चाहिए। बहुत सारी जगह अपन हमारे वो जैसा हमारे कॉलेज में या कोई यूनिवर्सिटी में हमारे जो मार्क्स रहते हैं वो दिखाने के लिए हम वो पेटेंट यूज करते हैं, लेकिन हमारे पास पेटेंट है तो उसका सोसाइटी के लिए क्या उपयोग है, उसके बारे में हम क्या काम करते हैं। आपको पता होगा कि फॉर एग्जांपल रामदेव बाबा है। अब रामदेव बाबा कोई कॉलेज में नहीं गए थे, वो कोई रिसर्च स्टूडेंट नहीं थे रामदेव बाबा, फिर भी उन्होंने पेटेंट बना के उन्होंने खुद काम चालू किया। आपको पता होगा कि आज रामदेव बाबा जैसे जिनके पास कोई पीएचडी की डिग्री नहीं है, कोई रिसर्च की डिग्री नहीं है, फिर भी उन्होंने अपने देश के हित में इतना बड़ा काम किया है। कभी कभी तो हमको ऐसा संकोच लगता है कि हम सिर्फ कॉलेज में लेक्चरर है या कोई क्षेत्र में काम करते हैं, हम पेटेंट की बात बहुत करते हैं, पॉलिसी की बात बहुत करते हैं, लेकिन एक्चुअल वर्क में है क्या, ये महत्व की बात है। जब हम पेटेंट के ऊपर बात, हम पेटेंट क्यों लेते हैं, काय के लिए लेते हैं, पेटेंट लेने के बाद में उसका हम उपयोग करते हैं क्या, एक्चुअली उसका उपयोग करने के लिए क्या करना चाहिए, लोगों ने कैसा उपयोग किया है। अब हमारे पास पेटेंट है, अगर हम उसके ऊपर कुछ भी ना करें तो पेटेंट का कोई मतलब नहीं है, सिर्फ हमारे पास नाम से पेटेंट रह जाएगा। मुझे पता है कि लोगों के पास 10-10 पेटेंट रहे, लेकिन पेटेंट रहने के बाद कुछ नहीं है। आपको पता है कि फॉर एग्जाम्पल चौधरी सर के पास 10 पेटेंट है, लेकिन फायदा क्या है? पेटेंट रह के फायदा क्या है कि हमारे नॉलेज का, हमारा जो ज्ञान है उसका हमारे देश को, हमारे समाज को फायदा होना चाहिए। हम जो भी करते हैं ना, जो भी वर्क करते हैं, जो भी हम टीचिंग का काम करते हैं, हमारा जो प्रोडक्शन है वो बच्चे है, वो हमारा एसेट है। वो एसेट सोसाइटी के सामने आना चाहिए, देश के लिए उसका उपयोग होना चाहिए। तो मुझे आज की डेट में हमारे टीचिंग इसमें किसी ने एक पेटेंट लिया है और एक काम किया है। फॉर एग्जांपल ये नागपुर यूनिवर्सिटी का ये कोई फैकल्टी है, ये लेक्चरर है, इन्होंने इसके ऊपर काम किया है, इसने ये पेटेंट के ऊपर ये पेटेंट के ऊपर अपने देश में इसका काम हो रहा है, हमारे स्टेट में काम हो रहा है, ऐसा कोई दिखता नहीं। इसलिए हम जब पेटेंट लेते हैं या कोई भी चीज का हम पेटेंट बनाते हैं तो इसका उपयोग होना चाहिए, ताकि हमारा पेटेंट ऐसा ही पड़ा नहीं रहना चाहिए सिर्फ हम हमारा एपीआई में बताते हैं। एपीआई में बताने से कोई फायदा नहीं है, वो तो हमारा रूटीन जॉब है, लेकिन उसका उपयोग सोसाइटी के लिए क्या है? आज की आवश्यकता है सोसाइटी के लिए हमारे पेटेंट का क्या आवश्यकता है। अगर सोसाइटी के लिए हमारे पेटेंट की अगर उपयोग नहीं है,
आपको भेजा मैंने वो अपना,
कोई पेटेंट करके कोई मतलब नहीं है। इसलिए मैं इस माध्यम से मेरा ये कहना है कि आज का जो वर्कशॉप है या आज का जो नेशनल इंटेलेक्चुअल प्रॉपर्टी अवेयरनेस मिशन है या प्रोग्राम है, ये जो प्रोग्राम तभी सक्सेस होगा कि हम हमारे फैकल्टीज को या हमारे रिसर्चर्स को कुछ दे सके। और मुझे ऐसा लगता है कि आज का ये जो आपका वर्कशॉप है, वेबिनार है, वेबिनार एक मायने में तभी सक्सेस होगा कि उसमें से कोई ना कोई लोग अच्छा नॉलेज लेके जाए और उस पर काम करे। काम करने की आवश्यकता है, भाषण देने की आवश्यकता नहीं। आजकल तो भाषण बहुत जगह मिलता है, नॉलेज इंटरनेट पे है, गूगल पे है, लेकिन कृति क्या हम करते हैं? आज कृति की आवश्यकता है। अब अगर हम इस माध्यम से ये चीज अगर हम ये हमारे लोगों के सामने लाएंगे या समाज के सामने लाएंगे तो मुझे ऐसा लगता है एक अच्छा योगदान अपना इसमें होगा, ऐसा मुझे लगता है। मैं आज घोषित करता हूँ कि आज ये वेबिनार का उद्घाटन हुआ है और आपके इस वेबिनार के लिए मेरी बहुत बहुत शुभकामनाएं। थैंक यू, धन्यवाद।
Thank you very much, sir, for inaugurating our webinar and giving us valuable suggestions regarding patenting filing. I would now start with the keynote address session. It will be my pleasure to introduce our keynote speaker and guest of honor of today's webinar, Dr. P.P. Maheshwari, Dean, Science and Technology, RTM Nagpur University, Nagpur. Formerly, Sir was Director of Jaidev Education Society, Nagpur, which runs JD College of Engineering and Management and JD Polytechnic in Nagpur. He is Professor Mechanical Engineering. Sir is double doctorate in Mechanical Engineering. First PhD is from University Institute of Technology conducted College of Rajiv Gandhi Technical University, Bhopal, in the specialization of machine design. Second PhD is from RTM Nagpur University in the specialization of thermal engineering, MTech design from BNIT. He is recipient of ISTE Best Engineering College Teacher of Maharashtra State 2019 Award by the Chairman of AICTE, Dr. A.D. Sahasrabuddhe. He has received ISTE Best Principal in Polytechnic of Maharashtra State 2020 Award. He has total experience of 34 years in teaching and administration. He has filed and published 10 patents. He has published 35 research papers in international journals of repute, international and national conferences. He also has authored 3 books and 3 book chapters on engineering subjects. His other achievements are Associate Dean, Academics, Dr. Babasaheb Ambedkar Technological University, Maharashtra from May 2020 to April 2022. Editor of Journal of RTM Nagpur University from 2020. Chairman, Board of Studies, Industrial Robotics, RTM Nagpur University, Nagpur, 2018 onwards. Member, Board of Studies in Mechanical Engineering. Member, Board of Studies in Mechanical Engineering of DBA Technological University from 2018 onwards. Chairman, Board of Studies, Mechanical Engineering, RTMNU, Nagpur. Academic Council Member, RTM Nagpur University. Member, Research Recognition Committee, Equivalence Committee, Chairman, Indian Society for Technical Education, ISTE Maharashtra from 2009 to 2011. National Executive Council Member, ISTE New Delhi, 2016 to 2008. MPSC paper setter for Mechanical Engineering stream. Co-convener, International Conference on Recent Trends in Automation and its Adaptation to Industries. Organizing Secretary 7th National Symposium on Cryogenics, a national conference. Organizing Secretary Industrial Problems in Mechanics and Mechanism, a national conference. Trainer, Strategic Planning and Institutional Developmental, ISTE New Delhi. Co-convener, International Journal of Automation, IFTOMF 2006. Member Staff Selection, Local Inquiry, Career Advancement Committee of Nagpur University. Member Institute of Engineers, ISTE AMM, IEEE. Editor Newsletter, Maharashtra Goa session of ISTE. It will be my pleasure to invite you, sir, for keynote address. Over to you, sir.
Thank you, madam. Thank you so much for your kind words. I would like to share my presentation. Am I allowed to share my presentation?
Yes, sir. You are close now.
Whether my presentation is visible?
Yes, sir. Yes, sir.
Is my presentation visible?
Yes, sir. It's visible, sir.
Visible.
Yeah. The learned principal of SK Purwal College, Kamti, Dr. M.B. Babde, the chief guest of today's function and the Honorable Pro Vice Chancellor, Rashtrasant Tukadoji Maharaj, Nagpur University, Dr. Sanjay Dudhe, Dr. Bharat Suryavanshi, who will be giving the keynote speech and is also an assistant controller of patent and design, Dr. Ratiram Chaudhary and his team, all the participants, a very good morning to all of you. I really congratulate the organizers for thumping participation of more than 1100 participants in this very, very important topic of intellectual property right. I know that the organizers did not leave any stone unturned to see that how best the participation can be there from across the country, and all the medias, including social media, are used to relay this particular program. I once again congratulate the Sanstha and the college with the team of Principal Dr. Ratiram Chaudhary and others who have taken a lot of efforts to see that this program on intellectual property right is very successful on the occasion of Azadi Ka Amrit Mahotsav and also Atmanirbhar Bharat. Now we will go to the, before we really start the presentation, I have been given, okay. Before we really start, I would like to tell you that why in last 10 years I'm observing suddenly the importance to the patent has come. If you just look at the countries which are having the population less than our country, except China, you will find that the number of patents with reference to the per 10 lakh population are lowest in our country. And this has been observed by the Honorable Prime Minister of the country, and immediately revolutionary changes have been taken place under the Ministry of Commerce, Department of Industry, Trade and Promotion under the Ministry of Commerce, and the Indian patent offices across the country to see that the number of patents increase. And I'm very happy to see that every year, rather every month, the number of patents are getting increased, and really the Ministry of Commerce is successful in enhancing the number of patents. I suppose that majority of the participants are from academics. So from an academic angle, if we see as to why filing, publishing, getting the patent granted, and then making it commercialized or license it is necessary from the angle of a teacher or from the angle of an academic institute, then you will find that we have a variety of rating agencies like National Institution Ranking Framework of India, then the Atal Institutional Ranking for Innovation Achievement, National Assessment and Accreditation Council, National Board of Accreditation, and variety of rating agencies which are there, which have suddenly started giving the importance to the patent. I mean to say the importance to the innovation, importance to the invention, importance to the creativity. All this has started almost 10 years down the lines, and now we have reached to a very respectable stage. When I see to the National Institutional Ranking Framework criteria, I find that they have specifically mentioned that how many patents are filed. They have given some mark to it. Then after filing, how many patents are published. This also has certain marks. How many patents are granted. That also has a mark, and how many patents out of granted are being commercialized or being given the license for in order to generate the revenue. And then I find that suddenly when I was reading the report of NIRF, wherein the IIT Chennai was at number 1, which has earned more than 2 crores of the revenue from the licensing fee of the patents, and they had more than 300 patents published and around 35 patents granted, out of which they have generated such a revenue. You will wonder to know that out of total number of patents granted, only approximately 10% of the patents are getting commercialized. So what our Honorable Pro Vice Chancellor Dr. Sanjay Dubey said is that filing the patent, publishing the patent, getting the patent granted is definitely very, very important in order to get it commercialized. But commercialization of the patent so that it can be utilized for the purpose of the society, for the purpose of the common man, is really very, very important. And that is what Honorable Pro Vice Chancellor has emphasized upon. But I'm a firm believer that if you want the patent to be commercialized, you need to file it. Once you file it, you need to publish it. And once you publish it, you need to get it granted. And right from filing to granting has a definite process. And that process takes around 3 to 5 years. Fortunately, because of certain changes which has been made at the level of the ministry, now the time which is required to get the patent granted has been reduced considerably. And even the fees which is being charged is also reduced considerably by the Ministry of Education, Ministry of Commerce, Department of Industry and Trade Promotion. Now, because you must have seen the 7th Pay Commission, I'm just telling you from the point of view of the academic institutions and the academicians. I, being the Dean of the Science and Technology of the Nagpur University, I know more about this, because the moment I have to file a patent on the name of the institution, say Rashtrasanta Tukadoji Maharaj Nagpur University, earlier the filing fee for a natural person, that is as Prashant Maheshwari, was 1,600, whereas as an institution it was 5 times, that was 8,000. But now Ministry of Commerce has made the changes that the academic institutions also will be treated as a natural person, and they also will be charged 1,600 rupees as the filing fee. So filing, there is certain fee, publishing, there is certain fee, granting, there is certain fee. All these fees were 5 times for an organization than an individual. Now these fees have been brought at par. Whatever fee charged to a natural person, that is Prashant Maheshwari, will also be charged to the RTMNU. So this is a major change, wherein filing the patent in the name of institution is being promoted, because may it be NIRF, NAC, NBA or Atal Innovation, everybody takes care, everybody looks into whether the patent is filed on an individual name or patent is filed in the name of the organization. And certainly if the patent is filed in the name of organization, is given the weightage more than the patent filed by an individual. Both are important, but when it is filed in the name of the institution, it has been looked from the point of view that this institution is giving patronage to those who are inclined towards innovation, those who are inclined towards invention, creativity, filing the patent. And that's why this has become very, very important. Now, this was my preamble as to why the patent filing, publishing, granting, and commercialization is very, very important. I would like to give you one more example, that when the university was to send the annual report to the government of Maharashtra regarding the activities of the Nagpur University, there a point was there, means everywhere they have started asking that how many patents were filed, published or granted, how many patents are commercialized. Even the state government is also asking while submitting the annual report. Even you will see that in the 7th Pay Commission, when a professor has to become the senior professor, an essential condition is that he should have been granted a patent. Everywhere it is there. And therefore, I request the Honorable Pro Vice Chancellor, who is the custodian of the Act, Ordinance, Direction and the regulations of the University of Nagpur, that in our PhD ordinance also, when the condition for becoming the PhD supervisor is that he should have published 2 research papers in the Scopus Index Journal or Web of Science, or 5 research papers as a first author in the UGC CARE listed journals, then there should be a condition. There should be a condition in or. It should not be a compulsory condition. Either 2 papers in the Scopus Index journals, or 5 papers in the UGC CARE listed journals, or a patent granted by the Indian Patent Office. Probably this will promote filing the patent, and our country will lead in terms of the other countries in innovations, commercialization, licensing, and earning the revenues out of it, especially which is required in the engineering and pharmaceutical industries these days. Let us try to understand the bibliographic details, because Dr. Suryavanshi is going to give you the complete detail, and he is the right person, being the assistant controller of the patent and design, who will give you the authentic important information. I would like to give you only the bibliographic details. That is, if I have to understand what is the intellectual property right, let us divide this intellectual property right into 3 words: intellectual property and right. Intellectual, we all understand, something which emanates from the mind, or creative labor of mind. It refers to the product that comes out of our ability to think and understand ideas. An idea is a product of careful mental efforts. You must have heard the Bloom's taxonomy. Those who are aware of the outcome-based education and the UGC guidelines on outcome-based education 2016, they are aware that there is a taxonomy given by Benjamin Bloom's in 1956, which he has divided the domain of learning into 3 parts. That is the cognitive domain, affective domain, and psychomotor domain. Here in intellectual property right, they talk about the cognitive domain. Cognitive domain means the thought process, the process of thinking, the application of mind, the application of gray matter. That is what is the cognitive domain. And cognitive domain again has 6 levels. Remember: understand, apply, analysis, evaluate, and create. See, the create is at the highest level of the cognitive domain of learning of the Bloom's taxonomy. It means the invention or filing the patent is highest innovative index considered in the world over as far as the innovation is innovation and the invention is considered. And that's why we say that whenever I talk about intellectual, I talk about the cognitive domain of learning. Even in the cognitive domain of learning, I talk about the topmost level, that is the creativity. And now property, everybody knows that, say for example, the room you are sitting into, you can feel it physical. The chair on which you are sitting, the table on which your laptop is kept. So the table, chair, laptop, pen, then the notebook which you are using for writing the notes, these are available in time and space. You can touch them, you can feel them. And a room, or if you have a flat or the land, you have the cell deed. And that cell deed indicates that this property is on your name. And at the end of the cell deed, you must have seen that the schedule of the property is given, that at the 4 directions of your property, what is being situated, which defines your property. So this property you are always aware of. To that I call as the tangible property. Tangible property means which you can feel, you can touch. You don't allow the trespasser to trespass your property, and you put a board that trespassers are not allowed. So these are tangible properties because they exist in time and space. Whereas when I talk about the intellectual property is not a tangible property. You cannot touch it, you cannot feel it. It is not available in the time and space domain. This property is intangible property. The idea which you have in your mind, the expressions which you have in your mind, the technological innovation which you have made. So unless it is fabricated, but then that idea, that thought process, that thinking is intangible. That's why we say that it is a property, but then it is a property which is intangible. And when I say that it is the property emanated from the creative human mind and is not available in time and space, that's why I call it intangible. It means when it is a property, I must have a right on it. Like somebody if trespasses your property, somebody if encroaches your property, you go to the court of law. By citing your documents or the sale deed, you say that this property belongs to me and how this person is trespassing, and by suitable enforcement, the suitable tribunal or the court decides that this property is yours, nobody has a right to trespass it. Similarly, this intangible property should also have the right of enforcement. If a patent is being granted in my name and that idea, those claims which I have made in the patent, and if somebody violates those patent, then I must have the suitable remedial agency, suitable agencies where I can put my grievances, and that suitable agency is either Indian Patent Office, Controller Indian Patent Office, or the Indian Patent Intellectual Property Appellate Tribunal, or the District Court or the High Court, which have been constituted for the purpose. When I say IPAB, it is the Intellectual Property Right Appellant Tribunal. So you can always go to this tribunal and ask for the suitable remedies or the enforcement of the right which has been granted to you, exclusive rights which have been granted to you in terms of the patent. And therefore, a right, if I define, then it is a legal entitlement which is recognized and can be protected, and the violation of which is deemed as unlawful and leaves the right holder with a remedy. As we have the remedy to the property which we own, which is available in time and space and which is a tangible property, in the similar fashion, the intangible property, which is the technological innovation, idea, expression, also has the remedy if somebody unlawfully trespasses your property, which is the patent, copyright, or the different types of intellectual property which have been told by the Honorable Pro Vice Chancellor also. Then let us come to, we have defined intellectual, we have defined property, we have defined right. Let us try to know what is IP. Now I am combining intellectual and property together, and then I will combine intellectual property right. So what is IP, intellectual property? It emanates, as I already told you, it emanates from human creative labor. It may include original ideas, research results, critical business information, design, and geographical indications. I will explain you what is geographical indication, what is design, what is trademark, what are trade secrets, and how these are obtained, which are limited life IPR, which are unlimited life IPR, that we will learn at the next slide. Then let us try to define the intellectual property right. What is intellectual property right? Intellectual property rights are those which protect applications of idea and information that has commercial value. Say, for example, I have been granted a patent, and that patent license I have given to somebody, and a third party comes in between and tries to duplicate that idea, tries to use that idea and puts its product in the market. Then I have a right, being the original patent grantee, having the exclusive right on that patent, can go to the court of law or the tribunal and can stop that person. I can bring the injunction on that person using that intellectual property which I have in my name, and even the court of law can grant me some compensation or some royalty for from the person who is illegally using it. Rights which protect products of human creative labor, and these rights, intellectual property rights, can be patents, as I told you, can be copyright, trademark, trade secret, geographical indications, and then there are many more intellectual property rights which are less popular, but then they are there in a particular case. Let us go to the next slide. Patent. How do we define the patent? Patent protects technological invention. This word you should keep in mind. Whatever are the technological invention, they are only protected by the patent. It can be a process and it can be a product. And then when I will tell this as an invention, I will define the invention at the later stage, but then when should I call that as an invention? It should have, there are three things which are very important to call any idea or anything as a patent. That is novelty, inventive step, and capable of industrial application. It should be novel, it should have the inventive step and capable of industrial application. What do you mean by the novelty? Novelty means it should have newness. That is, before you put it, before anybody else has done it, or whatever you have done it, nobody else has done it in the past. Or on the day when you file your patent, before that nobody has done it. That is what is the novelty. It is having something new, something novel, which nobody has done earlier, or it cannot be anticipated by earlier research papers, research literatures, non-patent literatures, or the patents which have already been published should not cite the idea or the process of product which you are going to file for the patent. That is what is the novelty. You must be aware that when we make the literature survey, in that literature survey, when we arrive at the research gap, in that research gap, we definitely take care of the work or the hypothesis. We take care in the literature survey that nobody earlier has done that particular work. And then only your work, which you are calling as the research gap, will be contributing or will be called as the original research or original contribution to the research. In the similar fashion, this is the novelty is novelty we come to know, because you have to go for the patent literature, non-patent literature, research, bulletins, technical articles,
Sir, you are not audible.
Yeah. Dr. Maheshwari sir, you are muted.
Am I audible now?
Yes,
Yes,
sir.
sir.
Yes, sir. You are audible.
Okay.
Sir, sir, again you have to share your slides.
Are you able to see my slide?
Yeah, yes, 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 yes.
Then we come to the copyright. Copyright means it is right to print, publish,
Mysore,
perform, or record the subject matter.
Mysore, sir.
Hello.
Yes, sir. Sir, try to
It,
complete. Sir, try to complete in 5 minutes.
hello.
Hello, sir. Hello.
Huh?
Sir, try to complete in 5 minutes.
Yeah, but I will finish this. So the copyright is something, if I'm writing a book, then that comes under copyright. If I'm recording a cassette, that comes under copyright. If I'm producing a film, that also comes under the copyright. Trademark is, it protects work / symbol which acts as source indicator of goods or services. If you see that the TCS has a logo, all the automobile of the Tata has a logo, and then you must have seen Audi has some logo. All the automobiles have some logo. So that is what is the trademark. Your institution has a logo. The RTM Nagpur City has a logo. That is what is the trademark. And design, you must have seen the Nike shoes of different design. Okay, so that design even is copyright. That design even is one of the IPR and can be registered. Trademark also can be registered. You can copyright your book, but then that is not, it doesn't require compulsory registration. Copyright is the only IPR which does not require compulsory registration. Even if you write at the word C and circle and copyright, that is more than sufficient for the copyright registration. Geographical indications means that, say for example, Darjeeling tea, Banaras sari, Kolkata rasogulla, Rockford cheese. So whenever the items are produced by the group of the people in a particular geography, that can be registered as geographical indicators. Nobody else can use that. And how do we define the invention? A new product or process involving an inventive step and capable of industrial application. Now, I told you that capable of industrial application means the utility. It should have the utility. It gives right to make, sell, use, offer to sell, or import an invention that comes under the invention. And now we define the inventive step, which is the last point I'm going to take. The inventive step is a feature of an invention that involves technical advance. The idea, process or product should have novelty. I told you what novelty is. Industrial, it should be capable of industrial application. I told you that also. Inventive step means that process or product should have the technical advance. Means it should have the higher efficacy compared to the product already available, or should have the economic significance. Means earlier, if it is available in rupees 20, and if you are capable of offering it at rupees 16 by way of changing some process or the methodology, then that is known as economic significance. So either your process or product should involve technical advance or the economic significance, or both. And that makes the invention not obvious to the person skilled in the art. That is the third condition. Say for example, if I'm going through a research paper published by you as a reviewer, and if I find that the research which you have done is a combination of two chemicals, and then you have produced the third chemical, and that anybody can do. I am a person skilled in the art, that's why I am reviewing your paper. And I feel that this would have been done by anybody. And this is very obvious. So that cannot be granted as a patent. So it should not be obvious to the person skilled in the art. And capable of industrial application, I already told you. Patent agent and patentee is also defined. If you just go to the Patent Act of 1970, all these definitions will be available to you. Then duration of intellectual property, limited life IPs. Patent is registered for the 20 years. It has 20 years life. After that, it automatically goes to the public domain. Anybody and everybody can go and make that product after 20 years. And copyright is age of the author plus 60 years, and unlimited life IP, for which there is no limit, but then after a fixed duration you have to renew it. That is trademark, granted for 10 years and can be renewed thereafter. Design, granted for 15 years and can be renewed thereafter. And geographical indications, indicators are granted for 10 years and can be renewed thereafter. So with this, I would like to put this. You must know IPO is Indian Patent Office. WTO is World Trade Organization. WIPO is a World Intellectual Property Organization, which is very, very important. Agreement is, TRIPS means trade related aspects of intellectual property, PCT, which is a very important treaty internationally, Patent Cooperation Treaty, and ACT means the Patent Act of 1970 as amended time to time. With this, I am thankful to the organizers and especially Professor Atiram Chaudhary and the learned principal for giving me an opportunity to speak on this topic of the intellectual property right and designating me as a guest of honor. I am thankful to you all. And thank you very much. I will give at the end only 2 suggestions to the participants that they should go to the Swayam NPTEL platform. There are 2 very important courses which are available. The first is Patent for Beginners, and the second is Patent for Scientists and Engineers. These 2 courses are delivered by the subject matter expert, Dr. Firoz Ali, who is the IPR chair at IIT Chennai. So if at all you are interested in going ahead with this IPR, then these 2 courses are very important. I may communicate to this later on to Professor Atiram Chaudhary, and then I can even tell you 6 subjects which you can do, and you can become the expert of the domain. You can even go for the patent agent examination, and your college can have the patent attorney who will guide the other teachers and the students as to how to file the patent. Thank you. Thank you so much.
Thank you very much, sir, for your excellent keynote address. Moving on further, I would now hand over the proceedings to Dr. Tushar Chaudhary, sir. Over to Tushar Chaudhary, sir.
Dr. Suryavanshi Maheshwari, sir, please stop your screen share. Hello, Dr. Maheshwari, sir.
Hello.
Dr. Maheshwari, sir, please stop your screen sharing so that we can proceed further. Yeah, thank you. Thanks a lot. Okay. Good morning, everyone. It is our absolute great pleasure to have with us Dr. Bharat N. Suryavanshi, sir, who is the Assistant Controller of Patent and Design at Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. Sir is our second speaker. Dr. Suryavanshi has a vast experience of 18 years. Sir has done PhD on a unique topic, which is bioefficacy and phytochemical studies on medical plant of Kinwar and Mahur forest of Nanded district from reputed Swami Ramananda Tirtha Marathwada University, Nanded. He has also done MPhil from prestigious Gulbarga University. He has completed post-graduation in biotechnology from the same university. Sir has many prestigious national and international research papers to his credit. Dr. Suryavanshi, as we all know, is a well-known speaker, and he has delivered lectures on IPR at various platforms all over India. Sir was deputed for training at Tokyo, Japan on examination and IPR issues. Sir has many more achievements, but due to time constraint, I won't give all of them. I humbly request Dr. Suryavanshi, sir, to kindly deliver his lecture. Dr. Suryavanshi, sir, please.
Thank you so much, sir. Good morning to all. I also welcome you all for the IPR session. As first, Maheshwari sir has taken all over the note of IPR, even though I'll take brief in all IPR and detail in patents by sharing my slides. Are you able to see my slides? Anyone, please?
Yes, sir.
Yes, sir.
Slides are moving?
Sir, no, sir.
No, slides are not.
Now you are able to?
Yes.
जस्ट अ मिनिट. हॅलो,
Yes, sir.
शेअर स्लाइड होत नाहीत, लवकर येऊन जा. हो हो. स्टॉप कर, प्रेस मिनिमाइज करूया, एंटायर स्क्रीन करूया. एंटायर स्क्रीन नाही होत असेल, असं नाही होत. ठीक. आता विचारून नाही मूव होत नाही ना. स्टॉपच करतो. स्टॉप स्क्रीन. एंटायर स्क्रीन कर पहिलं. एंटायर स्क्रीन कर स्क्रीन. नॉलेज. स्लाइड शो कर. स्लाइड शो कर. Sir, slides are moving now.
Yes, sir. Yes, sir. Now they are moving.
Now it's okay, na? Okay.
Yeah, it's okay.
Yeah, sorry for technical delay.
No, sir. No.
As you aware about the IPR, as Maheshwari sir told, but for more in detail, you can visit our website www.ipindia.gov.in for more details. If you want anything regarding patents, designs, trademarks, or geographical indication, you can visit our website. You will get forms, fees, even how to search in public domain. This is an awareness program. We cannot go in detail how to write the application, how to file the patent application. Therefore, we are conducting in-house program in the RG and IPM. So we are keeping update on our website as well as on Twitter account, that is RG and IPM, Facebook and Twitter. So if you want to be in perfect, like sir told you, there are many courses. So you can also, by joining our courses, you can become a perfect in writing, filing all the IPs. Let us see what is intellectual property. By seeing my slides, you might have thought that something which is product of mind is called intellectual property. Yes, but how it arises during discussion on any topics, any problem in and around us, or in the classroom, or in the lab carrying out research, then by discussion, something which is originating from your mind, something which arises from human intellect is called intellectual property. For example, in the December 2019, we heard about the coronavirus, but at that time we are not having any treatment method nor vaccine for that. Therefore, scientists all over the world started to do the research on the coronavirus. What is morphology? What is the genetic material of that? How we can bring a medicine for that? So ultimately, in the middle of 2020, we got a solution for that. That is Covaxin, Covishield, Sputnik. What is this? It's an intellectual property. Scientists thought on that problem. They carried out the research. Ultimately, they came with the solution. So something which is originated from human mind or product of human creation is called intellectual property. For example, I'll take another example. If I'm a mechanical engineer, if I'm developing new device which can convert solar energy into electrical energy, that's my invention because it comes from my mind by thinking on that problem. Another example I'll quote here. For example, we know petrol and diesel are not renewable sources of energy, but somebody's thinking that I should bring biodiesel in the market by doing some process. So the process of production of biodiesel is an invention because you thought on that problem, you got the solution. Again, a device which convert plant and plant products into an biodiesel. So something which is originated from your mind on any problem to gain solution, or it has an utility as sir told. Therefore, something which creates from your mind is called intellectual property. As sir already detailedly told about what are the different kind of intellectual property. Property means our minds go to the tangible form of property where I am having car, gold, plot, flat, so I'm rich enough. But there is another kind of intellectual property called intangible form of property. Therefore, it's an intellectual property. It's having industrial property and copyrights. Wherein industrial property includes patents, designs, trademarks, and geographical indications. Let us see one by one. What is the definition of intellectual property? What it means? Intangible creations of whom? Human intellect, having commercial value, asset like any other form of property. Always you should be an asset, but we are not giving importance for that. If you sell it, if you produce it and come in the market, or if you are giving licensing on it, you can earn from that. Therefore, it's an asset like other form of property like gold, flat, and plot. How we are giving our flats on rent, same way you can sell your technology in the market, or you can give license to that, you can earn from that in the form of royalty. Therefore, the definition itself says it's an asset like other form of property. There are different intellectual properties, as patent is called exclusive right, because if you get one's patent on your name, exclusively you can utilize it, sell it, or exercise the power on that. Therefore, it also called as a negative right. No one can exercise the power of that right. Patent is called territorial right because once you are applying patent in India, it's valid only in the territory of India. You cannot claim your right in other countries like USA, Japan, Germany, or any of the countries. If you want to file your patent application in those countries, you can choose two routes. One, PCT, as already Sir told, Patent Cooperation Treaty. It means you can claim a single application, you can file, and you can designate the countries in around 153 contracting states in the PCT. So single application can designate in all the countries if you are interested. If you want to do your business in those countries, if you want to get your right in those countries, you can file the application. Or as per section 135 of the Patent Act, conventional application. It means you are filing first application in India, taking the priority from India, filing in the country where you want to do your business. For example, you are developing technology in the form of electronic and telecommunication. So only China, if you want to file, take the priority from this, you can file in those countries. So separate applications required for the conventional application. Therefore, many people choose the PCT, one of the route to file the patent application in different foreign countries. Patent is also called as licensable right because once you are getting patent on your name, you can license to any company whom you want. For example, if you are developing the car which run on hydrogen fuel, then you can sell it Tata Motor, Hyundai, any company, those who are involved in the same field, and ultimately they will approach you for the technology what you are developing. Therefore, you can license to them and get the royalty out of that. Let us see what is patent then. Exclusive monopoly privilege are rights granted by the government to the patentee for 20 years from the date of filing or priority first filing for commercial gain in consideration of the full disclosure of his invention as a territorial right not only. When you are getting the right, when you are disclosing everything, not a single step you are supposed to live in that. Many people say that, sir, I have a process of developing something, 6 steps, 2 are very important, I don't want to disclose with you. No, as per section 10(4) of the Patent Act, you are supposed to disclose everything clearly with the examples. If you're drawings, if you're having drawings, if you're having sequence listing, you are supposed to give all details because after 20 years, somebody want to practice that invention. So you should not get any difficulty. Therefore, Government of India, as per the Patent Act 1970, it's one of the requirement that fully particularly you have to describe. Otherwise, you will get objection from the patent office that your application is not fully described the invention. So simply for this objection, your patent granting procedure may late. Therefore, keep in mind, always write in detail so that no one can object that one. Again, many people also taking the patent from ASEAN and many countries, but they are taking as a file record. As Maheshwari sir told, it should be have utility. It should help to someone else. Therefore, you can, it's an important, not keeping record and getting promotion of principal or state principal or any kind of professors. Therefore, it should work. It should fulfill the requirement of IPHN assets. Still, many are in confusion with what is discovery and what is invention. Many those, I have invented metal, I have invented microorganism, I invented this. No. First of all, you should understand, are you doing research or invention or you are doing discoveries? finding or exploring something which is already exists in the nature. Discovery has no technical effect. For example, we know the periodic table, we know the elements or metal of that. Somebody is isolating new metal or element, that's a discovery. But the process of isolation of that metal, maybe he using new device, new process parameters, then the process you can file as a patent application. Same way, I'll quote another example. For example, I am isolating a bacteria from cement effluents or jute industry. The process of isolation of microorganism may be new because I am changing media, temperature, pH, all the conditions required for that. But as such, isolation and discovery, because we know some of the effluents are having bacteria. So just I'm isolating. But if I am genetically modifying that microorganism by using recombinant DNA technology, then that is subject to patentable matter. Therefore, we should know whether we are doing this discoveries or invention. If it is invention, then go for the patent filing. What is invention then? Invention means new product or process. Again, it should be useful. It should be novel, non-obvious, not public knowledge before the filing date. Even for the paper publication, what we do, whether the work what I did, technology what I've developed is in public domain or not. If it is not in the public domain, then we go for the publication of paper. Same way, it should fulfill this requirement. Then only the technology what you have developed, research what you have carried out, the project what you have developed, or MPhil or PhD thesis what you have done the research is an invention. If it fulfills this, all those things. It's a very simple example of patent. In the year 1822, first time C.A. Boucher has invented sharpener. Term is now expired. Therefore, all the companies are manufacturing, they are in the market. So he has not told sharpener, he has worded the claim as a tool for sharpening a pencil writing point by saving away its own surface. This is the way of writing the claims, because patent is a techno-legal document. The technology what you have developed is you are covering with the legal tech support. Again, in the generalized, we learned since high school that Thomas Alva Edison has invented bulb, Alexander Graham Bell has invented telephone. All this we learned, but first time they did, therefore they got patent for that. But what are the two disadvantages of this telephone? There are two disadvantages with this telephone. You might have seen in the old movies, in any kind of Marathi, Hindi, all female movies having this. If I want to connect my near ones or friends 10 times, I have to dial. This is one disadvantage. Again, I cannot change from my cabin to my sir's cabin or colleague's cabin because it is connected at a particular point. To overcome these two disadvantages, scientists of electronic and telecommunication thought that they should do improvement over that. Therefore, they came with the button phones. At least one drawback you come that directly we can dial. But again, I cannot change from my cabin to my friend's cabins or somebody's cabin because again it is connected at a particular point. To overcome that, scientists of electronic and telecom thought they came with a cordless phone which was very long. I can take in the nearby like kitchen, hall, and drawing, but I cannot take in the meeting or outside or in the gym. Therefore, in the year 2000, we got the mobile in India, and it was very costly. So, what we are doing since 1876 to till today, we are developing the technology, mere improvement in the technology, and all got patent. Nokia, Samsung, Vivo, Reliance. Why? We are solving some problems. So always to get in patents, something new you are not doing. If you are solving any problem, also you are getting a patent for that technology. As Alexander Graham also got patent, but for Nokia, Samsung also we got patent because they are overcoming all the problems which were there with this telephone. Now you are sitting at your college. I am here. People of other parts of country, they are listening and speaking to each other. What is this improvement in the technology? What is existed in the year 1876? It's a recent example of Bluetooth. Before this, we are not having any tool to transfer the data. Now we are saying, I'm having mobile, I'll transfer in that Bluetooth, I'll transfer the data with you. What is this? It's a technology what was developed by Geoff Hudson, got patent for that. Nano car, hepatitis vaccine, these are the examples of patents because in technology. Again, this can drone, then the device which can, while giving birth to babies, should not fall in the ears or in face. So this technology all is got patent. Any process also. Most common by the inventors. Many people who are doing good things, but then run for the international publication and all. Publish the invention before filing the patent application. Don't go for the publication. First file, then go for the publication. Knowingly or unknowingly, if you are disclosing in some conferences or paper presentation, then first file the patent, or within 1 year from the date of that disclosure or paper presentation conference, you can file the patent application. Or if you are having the technology, if you are disclosing somewhere, please maintain the secrecy. Otherwise, somebody will copy and they file before you. If you are not sure that the project what you are carried out is having value or not, then wait till whole lab work is complete. Then recognize the value of that work. Then go for the filing. If it's having worth, then go for the filing. Otherwise, don't go for the patent filing. Let us see another kind of intellectual property called designs. Design means shape, configuration, pattern, or ornament, or composition of lines or color combination thereof applied to any article, 2D or 3D, or in the both the forms. If you check the Bajaj iron box, the design is different from the other company iron box. You can check the Ketan fan design is something different from Bajaj fan. Skyline hot heater is you may have something hot heater the different designs, comb designs, valet designs, glad designs. So all the designs are registrable if they are not in the public domain, if they are completely new. It should look beautiful to eyes, not mere functional or technical feature of the article are not considered design. Beautiful cup set is design, sofa set, chair design, spoon design, all the designs are there. Term is 10 years. You can extend up to only 5 years. Total is 15. We cannot extend more than 15 years. You say sanitizing machine. Earlier we are not knowing what is this. Now because of COVID, your campus is having this sanitizing machine. We are using this design also got registered in the government of India. Different designs. I'll show you what have registered in India. Ampoules, capsules, thermometers, all the designs whatever new, that is the register. So if you are also developing any design, you can go for the registration and get a benefit out of that. Textile designs, curtain designs, bedsheet designs, sari designs, shirt designs, jewelries, Titan, Timex watch designs, all the designs are registered. If you are developing new, go for the registration. If it is having novelty, you will get registered on your name and you can sell it to the fellow who is in the manufacture of that, and you can get the royalty out of that. These are bottle designs. There are different bottles, shape, configuration, and surface patterns of the water are different. All the designs shall register, which are looking beautifully. Again, design of toy school bus, badge, clock, pen, biscuit, pencil, sharpener, any kind of design. If a sharpener, we know different sharpener, but design is different. We know pencils, but the design is made in the parrot and peacock form. So something new. So all the designs have got registered. Bat we know, but he has made something look different. It is not in the public domain. Therefore, new design. So anything you can develop a new design and take benefit out of that by registering in the government of India. Let us see another kind of intellectual property, trademark. Visual symbol, which may be word, name, brand, or numerical or combination of colors to indicate the source of the goods. To distinguish from the goods of the others, it gives the authenticity of goods like Reliance, Airtel, Coca-Cola, Tata, Bata, Yahoo, all these marks got registered. It advertises goods and services, protect the innocent public from buying the goods of second-rate quality. For example, we know the Adidas. There are many second-rate quality products in the market. They will change the spelling ADIDAS. They will change something and they will come in the market. Pond's powder, POND spelling. If they make POUNDS, we never check what exactly register. We directly buy it. Therefore, we should know what exactly mark is registered, what is the design of that. R with encircle is a registered trademark. TM is trademark applied yet to get the permission from Government of India. Because once you are applying, it's go for the examination of the application. Then anything laconize there, they will send you the report. Then publication, then hearing, if any opposition, finally it's go for the registration. Then it is, you can use as R encircle. Duration is 10 years, can be renewed every 10 years subject to the usage. There are different marks like trade names, collective marks, certification marks, taglines, say it also Google, Adidas, Dilmange More, McDonald. All these marks are different from one to one. As Sir told about the geographical indication, just I tell the definition of that. It's an place names used to identify source of origin, quality, and reputation of that product. As Sir told, Kanchipuram silk sari, chappal, agrapeda, rasgulla. I'll show some of the examples like Darjeeling tea, Makrana marbles, Ratli Misev, again Kanchipuram silk saris, Katputli of Rajasthan, printings of Bagban printing of Madhya Pradesh, Bengal Patachitra, Chirali paintings, Bidri ware, Worli paintings, Magbai pan, Devanhalli palm hillo, Amedi mangoes, Kashmiri saffron, Sahilicha Bihar, Kurg orange. So that makes the difference because of geographical indications. The climatic conditions make the product totally different from that. Therefore, they got GI. In filing up other patents like patent, design, trademark, you can file, combine with the professors, students, or combine with anyone you can file. But in GI, a group of people who involved in the particular business only. For example, Nagpur oranges. The farmers of Nagpur having the association who are involved in the manufacture of that, in group, they can go for the registration, not individual. Copyrights, it's a bundle of rights, provides holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, software. The term is life of the author plus 60 years. Therefore, you might have seen many books were written by the authors. They were no more, but still they are getting the royalty for that. Many singers are sung the songs, they have been recorded, and still they are getting the royalty for that. So different works are being protected in this. Literary works, what you read, books, autobiography, or any story, novel you can get. If you are doing any artistic work, you can get for that. Dramatic work, if you are doing, you can get. Musical works, you can be protected. Sound recordings, even the cinematographic work comes under the copyright. How single product can be protected by different IPR. For example, you are developing some technology. So how you can protect so that other will not copy? In the year 2000 or in around that, Sony TV was very famous for clarity and sound. You might have seen, especially with the two hoopers on the top of that stereo. The remote control mechanism and technology got patented by the Sony company. How it looks beautifully with the color design, the Sony company has got design registration. The name Sony Assets got trademark. The instruction which are there in the box of TV has got copyright. Therefore, Sony got protection with all. Therefore, another company who involved in the manufacture of TV like Samsung will not copy neither patent, nor design, nor copyright, nor trademark. Therefore, plainly they are playing in the market. Independently, they are earning in the market. Therefore, if you also develop any technology, get protection, possible IPs so that other people will not copy your technology. Let us see what is trade secret. Trade secret is something, technology, which is not disclosed to the people. It is maintained secretly, never been disclosed to others. Therefore, I have taken one of the example as in pizza. You might have tasted Domino's pizza. The taste is different from the pizza which you get in the other hotels. Nowadays, pizza is prepared in other hotels, Domino's even in homes also. But the taste of Domino's is different because they're adding some trade secret which are not known to others. They will disclose the people who work in the kitchen of that Domino's with the non-disclosure agreement. They have to sign so that they will not disclose. The formula of Coca-Cola, we don't know. The formula of Mazda, we don't know because they are maintaining as a trade secret. This example to show how the designs have been registered for each company differently, how technology have been registered. Samsung you might see, Nokia you can see, Vivo you might have seen, Reliance Mobile, all the mobiles you might have seen because since long we are using the mobiles. In each phone we are having 3 to 4 mobile handsets. So if they are having different companies, the design is totally different because they got design decision. And even they got independently, they are playing in the market, they are getting profit in the market because they got the patent protection also. And even the name like Sony, Trademark, and even Samsung, Trademark, Reliance, they got all the right for that. Therefore, you can also protect a single product with the different intellectual property rights. What can do with the IPR? Why we have to study the IPR? Why government is making you to know about the IPR? This especially for the students. If you are a science graduate, you can become a patent agent. Yeah, every year our office calls for the patent agent examination. If you are a humanity graduate, commerce graduate, or law graduate, you can become a trademark agent or copyright law agent. If you are having knowledge of IPR, you can work in the IPR policies, IPR cell in the government, central government, and also universities also. Again, if you are having knowledge of IPR, you can work in the NGOs, and different IPR firms are in these different cities who are facilitating to file patent, design, trademark, and other IPs. If you are having MSc in chemistry, biotechnology, biochemistry, physics, and any branch of BE, you can join to the government of office whenever this comes, depend upon the vacancy. There are again 2 papers, one is objective, another descriptive. If you qualify, you'll get job in the government of India. Thousands of scientists like you, faculties like you, and students who are doing the research can also be an inventor, but they are not doing. Bolna. Hello? Hello? Some of the scientists can also be inventor, but they are not doing. They have to do simple research. मी lecture मध्ये आहे. हो 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 मी complete झालं की येतो. ठीक आहे. Sorry for that. By simple approach, you can become an inventor, but the people are not doing. For example, students are supposed to carry out their project. They are not doing the research. They are going to the libraries, copying the senior thesis, or just mere changing the data, and they are submitting the project to get a degree. But really, if you are doing the research in your own subject, definitely you can get a patent. Or if you're solving any problem, how? I'll give 1 or 2 topic how you can. For example, if you are a botany fellow, you can choose some of the medicinal plants and make a process of making a composition for dandruff curing. It's very new because Vatica is there, Sunsilk is there. If you are doing with the medicinal plants, it's a herbal shampoo. Or a composition of medicinal plants for psoriasis, skin disease. You can do it. If you are a microbiologist, a biological treatment of pond and river water, because chemical treatments are harming to the aquatic life of the animal. Therefore, you can give biological treatment for that. The process of production of alcohol from my campus waste of my plant, production of methane from my campus waste, or production of biodiesel from my campus waste of plants and plant products, or a device which can give alarm to the farmers on his mobile alert when the wild animals are entering his field. Because when your water tank fills, we get then alarm that water tank is filled. So why can't we prepare some device? One of the fellow in Nagpur of who is having 14 years old, he has developed a device which can make you alert that you are getting heart attack within span of some time. So many technology have been developed. So we have to research oriented, and what is not in the public domain, that we have to try to do in our own subject. There are many things yet to carry out the research. So if you really carry out simple research or any problem in this era, if you're solving that, you can get patent. For example, I'll give. We are being in the 21st century. In kitchen, still we are using holding our that gas cylinder with both the hands. We are checking how much gas is remaining in that cylinder. Because I want to book the gas, it should not come hindrance in my kitchen work. Why? We are in 21st century. Somebody use that knob which can indicate the pressure. Already one of the fellows developed now. It was needed long back, but now somebody has given the solution. Since long back, we needed technology that solar energy has to be converted into electrical energy, but nobody thought of. But now they are doing solar panels and all. So since long technology was needed, but now we are giving. So what is not in the public domain, we can give that. Definitely we will get a solution to that problem. Many vehicles comes on now. Vehicles are coming on which vehicle run on the electricity. So it was needed earlier since long back, but now we are doing. So if you think, definitely we can get a filter which can filtrate the air around us. Very simple invention. We can use domestic filter to filtering the air which in our room also, because at least we can get a pure air. There are many simple things depend upon their subject matter. If we solve, we can get patent for that. To get a patent, it should be novel, your subject matter, and should fulfill a requirement of inventive step, as sir already told you what is inventive step, and it should have an industrially applicability. Again, in India, apparatus, devices, machines, chemical products are patentable, and all the processes are patentable. When we can say your technology or your work is new, when it should not be published in India or elsewhere, it should not be in the prior public knowledge or prior public use within India, or it should not be claimed before in any specific in India or elsewhere. Then we can say the technology what you are developed is a new, fulfill the requirement of novelty of the patent. Another requirement to get the patent is it should fulfill the requirement of inventive step. As sir told you, it should be technically advancement. As I told you, telephone earlier, then now we got the mobile. That's a technical advancement. What is economic significance? Earlier we used the mobile when came in the year 2000, it's very costly. Now even 1,000, 2,000 up to 40,000 we are getting the mobiles because of improved technology. That's an economic significance or both. And that invention should not be obvious to a person's skill in that. As sir told, who is obvious? By combining, if he is a research paper evaluator, then he is the person who is skilled in that. He is evaluating your papers plainly by reading your both the papers. If he feels that I can do this research, this is obvious to him. Therefore, something inventive you are supposed to do, and that inventive should be fulfilled by surprising result. For example, I am taking ginger, tulsi leaves, and vinca roja leaves. These three is having antibiotic activity, but by combining this, if I am getting something more result, there's a surprising result. So you are fulfilling the requirement of inventive. Solution to a long-standing problem. Since long back, I needed a cylinder knob, but now we are giving. So if you are giving solution, fulfilled of a long felt need. Since long back, we needed a biodiesel, but we are not done. Great technical process. We got the great technical process. If you fulfill this, we are getting. Please mute yourself. Again, it should have utilities that is an industrially applicability. Then you can get patent for that. You came to know what is different kind of intellectual property rights, what is patent, design, trademark, copyright. Again, how to write the application if you are doing something new, like your PhD thesis, MPhil thesis, this in some particular format. You have to put the data what you are invented, and you can file the application. It should have title and preamble. Object, what is the object of your invention? Then prior art, what is the literature survey we call? You have to describe what is drawback in that and how you are putting the efforts to solve that problem. Statement of the invention, then detailed description. If you are having drawings, you can. If you are biological sequence, you can give the sequence. If you are having biological material, you can give that. Finally, you have to claims what you want protection. There are different kind of claims, independent and multiple dependent claims. Independent means a process for the preparation of cyclosporine or process of production of an herbal tea comprising steps of a process as claimant wherein one of the tea ingredients is ginger, process as claimant wherein one of the tea soap. So this is the way of writing the claims depend upon the subject matter what you are belongs to. For example, if you are doing mechanical, electrical, the subject is that, and you have to modify as per the requirement. Shortly, because of I have to go somewhere, so very shortly I'll give an example of foldable pen. We know what pen are because you are all teaching faculty. So these are the drawings you have to submit in this fashion to get a patent. This format, you should be like the total number of seat, applicant signature or applicant's agents. Then this is a title. This is a form to call. It is available on the website. You have to fill it and file it. Then what is the field of your invention? My invention relates to foldable pen. All out you can write 1 para, 2 para. What is the background? How earlier pen are not good. Therefore, I am giving this pen in the market. So all the disadvantages you have to give in 1 or 2 pages, that my pen is, earlier pens are very thickness, damage to the book can occur. The book is closed, the pen is between the pages. Further, it is possible to put the right such as advertising on the extra. So all the disadvantages of the pen you have to tell, because you are giving the new pen how it's better. Earlier we are having X-ray machine, but we now got CT scan machine. So what are the disadvantages of X-ray? We are overcoming the CT scan machine. Same way, what are the disadvantages of earlier pen? He's overcoming the, what is the new pen? He's telling my new pen is very good. When light flat, easier to put in writing on X-ray, and writing can be arranged on the easier to read also. So he's writing about his pen, what is advantage and disadvantage he's doing. Then what exactly he's doing, you have to give an explanation. He's telling my pen is having 3 parts, A, B, C. In that drawings, he's telling what figure 1, 2, 3 says, how the figure 1, 2, 3 act together to work as a pen. For example, if you are claiming new fridge, how that fridge works together to function as cooling effect, you have to explain in all drawings with example in detail. If you are making a medicine, then how you are making the medicine, you have given detail. Lastly, claim. I means single person, we means more than one applicant. A foldable pen comprising flat body of so and so shape, molded to form depressions, side depression acting as hinges, defining the panel such that body may assume 2 distinct shapes, either is virtually flat, hollow reservoir it's having to store the ink, third is a writing. So all these 3 parts pen is having, never full stop, only comma, semicolon you have to use. After completion of claim 1, you can use the full stop. Second, these claims are called preferred claims or multiple dependent claims. A foldable pen as claim 1, where is each panel is having same size. Foldable pen as claim 1, wherein each panel is beveled. It is truncated form. My pen is. So all the features you have to mention in the multiple dependent claims. Lastly, you have to sign and date the application. Now, how to file the patent application and where to file? Any person, individual, natural, startup, MSU, anyone can file the patent application. There is no age bar limit to file the patent application as per section 6. You can file physically going to the patent office, or we have given facility to file online since July 20, 2007. So you can file online by sitting in your own office or home. There are different jurisdictions, as Mumbai covers state of Gujarat, Maharashtra. So you belongs to Maharashtra. You are supposed to file in those Mumbai only. What are the minimum documents required? Form 1, to detail about the applicants, applicant address, type of application, all details you have to mention in the Form 1. In that para 9 of Form 1, it has to sign by the inventor to declare the inventorship and proof of rights. Form 2, to say the complete application or provision. Form 3, whether you are filing in for foreign countries or not, you have to mention in Form 3. Form 5, to declare the inventorship. For example, in paper publication, we add first author, second author, third, fourth, our lab mate's name. If you want like that, you can add in the Form 5 as an inventorship. But in Form 5, in patent, you get all will get the equal rights on your patent. Therefore, keep in mind whose name you have to enter in the Form 5. Form 18 for request for examination, and fees in the form of DD. If you are filing online, you can pay. Online fees is 1,600 for natural person, for others 800 up to 30 pages. If you are more than that, each page and each claim will be different fee. Fees may change always. Keep in mind, visit to website and check once before filing. And all the teaching institution has got 80% fee concession as Government of India announced, because most of the inventions are coming from teaching institutes. In other countries like USA, China, all countries, many of the teaching faculties are filing more on patents, and students also. Therefore, government is giving you 80% fee concession. So please take the benefit of this and file more and more patents. Form 18 fees, 4,000 for natural person, 20,000 for the others. This is an optional form, not compulsion. If you want to express publication, you can publish by requesting and paying the extra fees. If you want early patent, then you can spread examination, you can file as per Rule 24B. When you can file, while filing ECT application, and choosing India as an international searching authority or international preliminary exemption authority, or applicant is a startup, or as per 2019 rule, one of the applicant can be ladies or government organization. Then you can request for the expedite examination. Fees is 8,000 for individual, 60,000 for the company. You can get very soon patents. There are various forms you can get on this website. If you want to file online, IP India online that you have to visit, you can file. How we are granting you the patents? Once you filing the patent application, it's go for screening and classification, depend upon the subject matter. Electrical, electronics, mechanical, biotechnology, microbiology, many fields are there. So we classify by using the international patent classification system. If you are requesting for early publication, we publish within a week or a month. Otherwise, it takes 18 months for publication. After publication, any person can file the pre-grant application by way of representation. Anyone can file. It is stolen from me or publicly known or any ground. There are A to F grounds are there under pre-grant opposition as per section 25. You can check, you can file the opposition. If you are requesting for examination within 48 months, then it's go for the allotment to the examiner and controller. Examiner carry out the search, make the gist of formal and technical objection, and forward to the controller. Controller again search, modify, delete or objection, then make the final gist of objection and forward to the applicant or applicant agent whose address is on Form 1. That is called first examination report. Once you receive the first examination, you are supposed to reply within 6 months. If you are unable to reply, you can take extension of 3 months by filing Form 4 with the prescribed fee, and you can take an extension of that. If all the objections met, if you have filed the reply, it's good, it will be granted. If you are unable to or fail to meet the requirement, it will be rejected, or it will give the opportunity of hearing also. In hearing, you have to satisfy. If you are unable to, then it will be rejected. If it is granted, then again it's go for the publication of grant. Within 1 year from that publication, any interested person can file the opposition. Earlier, any person can file the power, but here, interested person can file the opposition. Now, who is the interested person? For example, Maruti Suzuki is doing some new engine, inventing some new design or engine, then he is getting patent for that. Then Hyundai, Tata Motors, Mahindra can oppose that because they are involved in the same motor business. Therefore, they are called person interested. In pharma, if Omicron, if Serum Institute develop a vaccine, then Bharat Biotech of Hyderabad or Sun Pharma, Ranbaxy or Biocon of Bangalore can oppose that because they are involved in the same business. Once post-grant application filed, the same gist of objection communicated to the applicant. Applicant give all the on each in detail. The same reply forward to the opponent. Then again, opponent give the reply for that. Again, inside the office, we consider the opposition board. There are 3 officers. One is chairman, 2 are the member of that board. Again, we give the recommendation of the opposition board by that committee. That is called opposition board. If the applicant or opponent requests for the hearing in the post-grant, applicant, opponent, their lawyers, even controller, examiner with the help of opposition board recommendation, they come to conclusion that whether we have to grant or reject. If applicant is able to overcome all the grounds of opponent, then it go for the grant. If applicant fails to overcome the grounds of opponent, it will be rejected. So if we are granting or rejecting, we are giving the speaking orders so that we can appeal our orders in the high court or higher courts. Therefore, and if we are granting, same day we issue the certificate of grant. What is the role of patent system? Encouragement or improvement of technology from telephone to mobile phone we got. Providing reward as an exclusive right for disclosure. If you are disclosing everything, you are getting reward for that from government of India, that is patent. Making profit or earning royalty through putting the invention in practice. Don't keep patent as a file record. Let it get the utility and benefit to all. Transferring into public property after expiry of term means after 20 years, or if you are unable to pay the renewal fees, it will be seized. Then anyone can use your patent application. What to do now? What to do now? Because I came to know all about the patents, design, trademark, and GI, how to file, how to write the application also, and importance of that. Don't keep quiet. Share the benefit of patent system in classroom, colleges, universities, or in the public domain wherever you get the opportunity. Utilize the resource through organized R&D activities. Capture the global market judicially, earn profit through the protected markets. Thank you.
Thank you, Suryavanshi sir, for your valuable guidance. It was a really nice gesture from you for sparing such a valuable time with us. The presentation given by you was a very nice one, and the information which it has yielded will be significant for all of us for our lifetime. The token for the success of your speech uh, states that there are so many questions which our participant has asked. Many of them were solved during your presentation, but still there are certain questions. I
Yes,
would like to
please.
request you to kindly,
Please
solve
read,
it.
read the questions. Read the questions.
Yeah, please. The first one is, can we publish a research paper of which copyright is granted?
Once your copyright grant means you already it is granted, so no one can take your that copyright material. So it is left to you, depend upon you. But already Government of India has given you the right that already copyright has been assigned to you. No one can copy your work.
The second one question is from by Gabriel Prabhu. He is asking that IPR published design patents are shown in the WIPO patent list. Are you getting my question?
No, sir, I am not getting you.
IPR published design patents are shown in the WIPO patent list. If you file patents under IPR, then whether they are shown in WIPO patent list.
Yeah. For example, if you are filing patent application in India, it's shown in our website only, that is ipindia.in. If you are filing the PCT country, then WIPO, World Intellectual Property. WIPO means World Intellectual Property. It's published there. So depending upon which country you are filing, there it will be published. Okay. And any published document you can check on your website of their own patent offices.
Yes. Another question is from our dynamic research fellow, Ajay Podvare. He's asking, according to you, reference any job opportunities in Nagpur for patent analyst? Is there any job opportunity for young researchers for patent analyst designation?
Sir,
like that?
there are many job opportunities you are supposed to search. We cannot advise you and we cannot refer you also, because being a government servant, I cannot, but there are many, you can check in the ads, many ads are coming. Mechanical patent analyst required, civil is required, electronics is required, pharma is, many ads are coming. And with the IPR groups, if you are having, they are posting each others, but I cannot suggest you being a government servant for that. But there are many possibilities are there.
The last question is, sir, is it necessary to disclose all the methodology and formula of invention?
Yes, as per requirement of section 10(4) of the Patent Act, you are supposed to disclose everything to meet the requirement of section 10(4) of the Patent Act.
Now our convener, Dr. Ratiram Chaudhary, is going to ask his question to you.
Yeah, sir, please, because I'm in hurry. The program was scheduled at 11:30, but it was been 1:30 up to. Yes, sir, any question?
Hello, sir.
Yeah.
Well, sir, it was wonderful your talk. So let's say congratulations to you. And on behalf of Purval College, really I'm thankful to you. There are a number of questions. It means that your talk was really impressive and
please ask questions.
Yes. Okay.
Yeah, I have to
so I would like to ask the question. You have mentioned that, and you have told already that 1,600 rupees to have that is the registration fee. Okay, and then again some fees you have told. Okay.
Yeah, you can check in the website. All the detailed fees are there. It is not a
supposed to be my my patent is granted. Yeah, before granted, is there require any lawyer and I have to pay the money of that?
No, you can file your NSFBC. You are writing PhD thesis, then why can't you get an agent for that? You can write on your own, but you should know how to put in the particular format. That's all. The format is changed from that to this. I told you what is the content of that. And search in our website. You can take a simple patent printout, read that one or twice. You will be, or you can attend our courses where we teach about the drafting and come to know. No need of hiring. Being a government servant, we never suggest you to go to an agent. It is left to you.
Because some people are saying that whenever asking to other people, they are saying you need near about 40 to 50,000 for the one patent. So
Not
is it
like that.
correct?
1,600 filing and 4,000 for request for examination. If you want to early publication, then 2,500 extra fee. That's all. More than not required at all.
Okay.
So you can check the fees and you can file. As I mentioned you, it was very long lasting. So I have to leave for this session. I leave. Thank you so much for you. Any doubts or email IDs are with you. Even my contact number is sir. Please contact me as I have one assignment. That's why I requested sir you also to conduct at 11:30, but it has gone long. So sorry for that.
Okay.
Anyhow, anytime you can call me or message me or email me. I am here to help you out. We are being government. We are very much eager to tell all the people about the IPR. Thank you. Bye.
Okay, so thank you so much.
Thank you, sir. We at the Porval College family is humbly appreciates your presence and your guidance on this occasion. Now I request the president of today's webinar, our principal, Dr. Bagre sir, to kindly give his presidential speech. Dr. Bagre sir, please.
First of all, I would like to congratulate the team who has organized this webinar, and we got huge response for this webinar from the participants. So once again, I congratulate all the team members who were involved in this webinar. Secondly, I would like to thank Honorable Pro Vice Chancellor Dr. Dude sir for his inaugural remark. And I would also like to thank Dr. Maheshwari. He has given the in-depth knowledge about the patenting and copyright and all these things. And most importantly, Dr. Suryavanshi has given a very detailed picture of the patenting, copyright, the GI tag, and all that things. So he has actually explained the process in a very short span and in a very detailed manner. So definitely this will be the very useful thing to all researchers in the science field or in the humanities or in the commerce and management, because this patenting is applicable everywhere, either in one form or other, maybe in the patent form or maybe in the copyright or maybe in the GI tag or some in every way. There's even in the literature also, this is very useful. So I hope everybody who joined this webinar will get benefited by this webinar and by the knowledge of the learned person. And this information is authentic from the government sources. That's why here everybody should use this information and go for the patenting instead of writing the papers in the journals. Here you will get the more weightage in the patent. No doubt the process is quite lengthy, but we will get more weightage for your research work or for your contribution. And I hope the new researchers, budding researchers, or the, you can say the writers or artists, they may get the more credit about their work. And I hope this information that can be cast by everyone. And I'm thankful to all the three speakers and the team members who has made this webinar a very successful event. So thank you very much.
Thank you, sir. Your advice has always been source of inspiration for us, and because of your encouragement, we are being able to arrange such kinds of webinar. Thank you very much, sir, for your kind support. Now we are coming to the conclusion of this webinar. I request our dynamic Joint Secretary, Dr. Mundal sir, to kindly deliver a formal vote of thanks. Dr. Mundal sir, please.
Thank you, Tushar sir. So now we have reached to the end of our event. So I, Dr. Sudeep Mandal, on behalf of organizing committee, stand here to propose a formal vote of thanks. First and foremost, my sincere thanks to Shikshan Prasadak Mandal Kamti for providing us the necessary facilities. We are thankful to Chief Guest of today's program, Dr. Sanjay Dudhe sir, Pro VC, RTM Nagpur University, Nagpur, for sparing his valuable time with us. We are grateful to President of today's function, Dr. M.B. Bagre, Principal of our college, for making available all the necessary facilities and inspiring us. Our sincere thanks to guest of honor, Dr. Prashant Maheshwari sir, Dean Science and Technology, RTM Nagpur University, Nagpur, for his valuable time and sharing his wonderful talk in this event. We are grateful to today's resource person, Dr. Bharat Suryavanshi sir, Assistant Controller of Patent and Design, RGIPM Nagpur, for illuminating us with the knowledge on IPL. We are also thankful to Vice Principals of our college, Dr. V.N. Chauhan, Dr. R.A. Tiwari, and core committee members, Dr. R.J. Chaudhary, Dr. P.R. Dhongle, Dr. T.V. Chaudhary, Dr. S.J. Chahande, for putting their best effort to make this event a successful. And now, last but not the least, we are highly thankful to all the participants, those who have joined through different platforms, Zoom as well as YouTube, for their kind support for making this event a grand success. With this and with the permission of Chair, I declare the program is end here. And for the participants, one information that feedback link will be shared in the WhatsApp group only, and you are requested to fill the feedback form and wait, and your patience wait is also appreciated, that because it will take some time to make the certificate. So first and foremost, what you should do, you fill the feedback form and wait on the WhatsApp group, and do not leave the group till you get the certificate. So feedback link you will get on WhatsApp group. Thank you all.
Thank you, sir.